Employment Law Learning Outcomes. 1. Canvass an overview of Canadian employment law, including through the life cycle of employment. 2. Identify and differentiate between different classifications of workers in Canada, such as employees, independent contractors, and dependent contractors. 3. Analyze the key elements and components of an employment contract. 4. Examine the purpose and provisions of the Employment Standards Act, including minimum wage, working hours, overtime, vacation entitlements, and other statutory requirements. 5. Evaluate the legal framework and considerations involved in terminations, distinguishing between terminations with cause and terminations without cause. Introduction. In this chapter, we will cover employment law, which serves as the cornerstone of regulating the rights, obligations, and protections of individuals in the workforce. It is admittedly a broad topic encompassing issues such as hiring practices, wages, working conditions, and termination procedures. Having a deeper awareness of each of these topics can help individuals navigate their employment with confidence and ensure they are better positioned to protect their legal rights. From an employer's perspective, staying up to date on ever-changing employment regulations is vital, as it can help promote a successful and healthy workplace, as well as avoid legal disputes with employees. Importantly, this chapter will only focus on non-union employment and not deal with the laws and regulations in a unionized workplace. Employment law is very different from labor law, and thus, it should be remembered that the laws governing unions are fundamentally different than the non-union setting. Work is one of the most fundamental aspects in a person's life, providing the individual with a means of financial support and, as importantly, a contributory role in society. A person's employment is an essential component of his or her sense of identity, self-worth, and emotional well-being. Reference Public Service Employee Relations Act, 1S. CR 313. At page 368, Employment Law Framework. Canadian employment law is a blend of statutes and common law principles. Together, this combination creates a comprehensive legal framework governing employment relationships. Like all the provinces and territories, there are numerous statutes in BC which place boundaries on the relationship between employees and employers. Some of the major BC statutes include Employment Standards Act. This statute sets out the minimum standards for employment in BC. It covers various aspects, such as minimum wage, hours of work, overtime, vacation entitlements, leaves of absence, termination, and other basic rights and obligations. Human Rights Code. The Human Rights Code prohibits discrimination and harassment based on protected grounds, such as race, gender, age, religion, disability, and sexual orientation. It ensures equal treatment and addresses issues related to workplace discrimination. Workers' Compensation Act. The WCA establishes a comprehensive system for providing compensation to workers who suffer work-related injuries or occupational diseases. It also outlines the rights and responsibilities in relation to workplace safety and health. Importantly, these statutes govern different and specific issues of employment, and therefore, it can be a challenge for employees to have a clear sense of their rights and where to seek a remedy. While we cannot canvass all aspects of the various statutes, we will cover some of the fundamental pieces to the puzzle. Types of work relationships. Given that we are focused on employment law, we would expect that our discussion would always involve employees. However, not every person that works is an employee. There are numerous ways to structure a work relationship, including as employees, independent contractors, and dependent contractors. The distinction between the worker categories is hugely important because it determines the level of protection and benefits that a working individual is entitled to under the law. For instance, employees are entitled to a range of protections and benefits, such as minimum wage, vacation pay, and employment insurance, while independent and dependent contractors, to varying degrees, are not. Employees. An employee is someone who provides services to an employer in exchange for compensation and is generally subject to the direction and control of the employer in terms of their work. A key characteristic of being an employee is continuity. The relationship between an employer and an employee is ongoing and not typically limited to a one-time or short-term arrangement. As an employee, the work or engagement is expected to persist over a certain period of time, often as an indefinite relationship with no predetermined end date. Further, if there is an employment relationship, employers are responsible for deducting and remitting various taxes from the employee's wages, including income tax, Canada Pension Plan contributions, and employment insurance premiums. These deductions are made on a regular basis and submitted to the appropriate government authorities. Independent contractors. An independent contractor refers to a person who is engaged by another party to perform specific tasks or services on a contractual basis. Unlike employees, independent contractors are not considered to be controlled by the employer and therefore are not entitled to the same rights and benefits as employees. Independent contractors tend to have more flexibility and control over their work. They are responsible for their own taxes, insurance, and other business-related expenses. Independent contractor, one who undertakes to produce a given result, but so that in the actual execution of the work, he is not under the order or control of the person for whom he does it, and may use his own discretion in things not specified beforehand. Pollock on Torts, 15th edition, page 63. A few common occupations that are frequently based on an independent contractor relationship are the following. Freelancers, self-employed professionals who offer their skills and services to clients on a project basis. They often work in creative fields such as writing, graphic design, web development, photography, and event planning. Professional services, professionals such as lawyers, accountants, consultants, financial advisors, etc., are experts in a particular field who provide specialized advice and guidance to businesses or individuals. They may offer strategic services, but they are not employees of that company. Instead, the professional is retained on contract to perform their specialized task. Tradespeople. Skilled tradespeople such as plumbers, electricians, carpenters, and painters can work as independent contractors rather than as employees. They are hired by individuals or businesses to perform specific tasks or projects and are responsible for their own tools, equipment, insurance, and taxes. Fitness instructors, personal trainers, yoga instructors, and other fitness professionals often work independently, offering their services to multiple clients or fitness facilities. They may conduct one-on-one sessions or group classes for a variety of businesses. Delivery drivers. Many individuals now work as independent contractors providing delivery services. They use their own vehicles to transport goods or food from businesses to customers. The emergence of the gig economy has certainly led to an expansion in the use of workers labeled as independent contractors. Think about the following businesses and how they rely on independent contractors rather than employees. Dependent contractors. Dependent contractors are recognized as a middle ground between employees and independent contractors. Dependent contractors are individuals who are economically dependent on a particular organization for their livelihood, even though they may not be considered employees in the strict legal sense. These individuals are not considered employees, but they are also not considered to be self-employed. Dependent contractors exhibit characteristics of both independent contractors but also employees. Like employees, dependent contractors have a significant economic dependency on a single organization, but like independent contractors, they retain some degree of independence and control over their work. Given that dependent contractors are a middle ground, the law ensures that dependent contractors have access to certain types of employee protections like minimum employment standards and legal remedies in the case of wrongful dismissal. As an example, imagine a technology company engages a software developer on a long-term basis to work exclusively on its projects. The developer is not an employee but works full-time for the company, follows its instructions, uses its equipment and software, and does not have other clients. Despite not being an employee, the developer is economically dependent on the company for their income and lacks the freedom to pursue other opportunities. In this case, the developer may be considered a dependent contractor, entitled to some of employment-related protections and benefits that employees receive. Myth-busting myth. I'm not an employee, so I'm not entitled to work protections. Incorrect. In reality, many workers who are labeled as independent contractors may actually be considered employees under the law and therefore are entitled to various legal protections. The determination of employee status depends on multiple factors, such as the level of control exercised by the employer and the nature of the working relationship. So, you need to examine how you actually work to determine if you are truly an independent contractor. Given that many rights and protections are available to employees, but not independent contractors, it becomes crucial to properly establish the classification of a worker. It is also true that some employers may label employees as independent contractors to restrict some of the protections afforded to that worker. Given the stakes, how then do we determine if a worker is an employee or independent contractor? The determination of worker classification is based on a legal test commonly known as the fourfold test. Control. This factor considers the degree of control exercised by the employer over the worker. If the employer has significant control over how, when, and where the work is performed, it suggests an employment relationship. For example, if a worker is required to follow specific instructions, work set hours, and report to a supervisor, they are more likely to be classified as an employee. Ownership of tools. This factor examines who provides the tools, equipment, or materials necessary for the work. If the employer supplies these resources, it leans toward an employment relationship. On the other hand, if the worker provides their own tools, it suggests an independent contractor arrangement. Chance of profit, risk of loss. This factor considers whether the worker has an opportunity for profit or bears the risk of financial loss based on their performance. Independent contractors typically have a chance to make a profit or incur a loss based on their business decisions, while employees receive a predictable wage or salary. Integration. This factor evaluates the level of integration of the worker's services into the employer's business. If the worker's services are integral to the employer's operations, it suggests an employment relationship. Conversely, if the worker's services are separate and distinct from the employer's core business, it leans toward an independent contractor arrangement. No single factor is determinative, and the entire working relationship must be considered as a whole. However, the control test is often viewed as one of the most important factors for conclusively determining the classification. Foundational Law 649905 Ontario Ltd. versus Sagas Industries Canada 2001 SEC 59. The Sagas case is one of the most significant legal precedents for determining the classification of a worker as either an employee or an independent contractor. In the case, Sagas Industries, a company engaged in the manufacture and distribution of industrial brushes, hired salespeople to promote and sell their products. The company classified these salespeople as independent contractors, which meant they were not entitled to certain legal protections afforded to employees. However, the salespeople argued that they should be classified as employees, as their level of control, dependence, and integration with the company suggested an employment relationship. In the decision, the SCC crafted what is now referred to as the fourfold test. The central question is whether the person who has been engaged to perform the services is performing them as a person in business on his own account. In making this determination, the level of control the employer has over the worker's activities will always be a factor. However, other factors to consider include whether the worker provides his or her own equipment, whether the worker hires his or her own helpers, the degree of financial risk taken by the worker, the degree of responsibility for investment and management held by the worker, and the worker's opportunity for profit in the performance of his or her tasks. 649905 Ontario Ltd. versus Sagas Industries Canada 2001 SEC 59 at para. 47. Ultimately, the decision highlights the importance of focusing on the underlying nature of the working relationship rather than the specific label given to the worker. Sagas is also the clearest conception of the four-part legal test now used to evaluate a worker's status. Example: utilizing the fourfold test, imagine an employer, Tech Solutions, hires a computer programmer, Sachi, to develop a software application. To determine if Sachi is an employee or an independent contractor, we can consider the fourfold test. Control: Tech Solutions allows Sachi to set her own schedule and work remotely. She has the freedom to decide how to approach the programming tasks and is not closely supervised by the company. This suggests a lower degree of control, indicating an independent contractor relationship. Ownership of tools: Sachi uses her own computer, software, and programming tools to complete the work. Tech Solutions does not provide any equipment or resources. This again leans toward an independent contractor relationship, as Sachi supplies her own tools. Chance of profit, risk of loss: Sachi's contract with Tech Solutions specifies a fixed project fee for the software development. If Sachi completes the project efficiently and within budget, she could potentially earn a higher profit. Alternatively, if she faces unexpected challenges that increase the project's cost, she would be the one to absorb these extra expenses. This indicates that Sachi is the one who has the chance of profit or risk of loss, suggesting an independent contractor relationship. Integration. The development work performed by Sachi is separate and distinct from Tech Solutions' core business. She is hired on a project basis and does not contribute directly to the company's day-to-day operations. This points toward an independent contractor relationship. Considering all these factors, Sachi would likely be classified as an independent contractor. She has control over her work, uses her own tools, faces a chance of profit or loss, and provides separate services that are not deeply integrated into the company's operations. The employment contract. One of the principal reasons you may contact an employment lawyer is because you have just been presented with a written employment contract. It is often recommended by employers that you obtain independent legal advice about your employment obligations. This is such an important principle that often the contract itself will have a clause dealing with independent legal advice. The parties agree this agreement constitutes the full understanding between them on these issues. The employee further acknowledges and agrees that the employer fully understands the terms of this agreement. The employee acknowledges that the employee has had independent legal representation in connection with this agreement or the opportunity to obtain same, and that the employee voluntarily enters into this agreement. Ottawa versus Letourneau, 2005 KI 1407 at Para. 57. Given the importance of the contract to the employment relationship, it certainly makes sense that understanding the law affecting the contract should be a priority. While this chapter cannot substitute for the guidance of an employment lawyer, it can highlight some of the major elements and terms dealing with employment agreements. Form of the employment contract. It is worth noting that not all employment contracts are required to be in writing. Employment contracts can be formed through verbal agreements or through a combination of written and verbal terms. It is absolutely possible that an employee does not sign a written contract of employment. However, they are still entitled to legal protection. When a worker agrees to provide services to an 196 FOUN DATIONSOFC NADIANBUSINESSL W employer, and the employer agrees to compensate the worker in return, a contract is formed. That said, having a written employment contract is highly recommended as it provides numerous advantages to both parties. For employers, the written contract allows them to clearly define the terms of employment, including job duties, work hours, compensation, benefits, and other important provisions. This clarity helps prevent misunderstandings and disputes in the future. Employers can also use employment contracts to protect their business interests by including provisions such as probation, non-disclosure agreements, non-compete, non-solicit clauses, or ownership of intellectual property rights clauses. Lastly, written contracts may provide an employer workforce flexibility by restricting the length of the employment, such as using a fixed-term contract. Employees also benefit from written employment contracts as they can clearly see their rights and entitlements. This likely includes provisions related to wages, overtime pay, vacation time, termination notice, or severance pay, and other benefits. Having these terms in writing gives employees a legal basis to enforce their rights if any disputes arise. Myth-busting myth. I didn't sign anything with my employer, so I don't have an employment contract. Incorrect. The idea that having a signed document is the only way to have an employment contract is a myth. In reality, an employment contract can be created verbally or through conduct, and it is still legally enforceable. A formal written agreement is not always necessary to establish the existence of an employment contract, as the terms and conditions of employment can be implied or inferred from the actions and behavior of the parties involved. If you're doing work for money, you have an employment contract. What makes an employment contract enforceable? While parties may believe they have an employment contract, there's no guarantee that it is legally enforceable, as an employment agreement is just a form of contract. Its enforceability requires the same elements that were noted during our general discussion on the enforceability of a contract. To be valid, the following 6 elements must be present in the employment contract. IDOT offers an employment contract begins with an offer typically made by the employer to the employee. The offer sets out the terms and conditions of employment, such as job responsibilities, compensation, benefits, working hours, and other relevant details. The offer does create binding obligations on the employer and employee. The offer can also be revoked any time by the employer prior to the employee's acceptance. 2. Acceptance. Once the offer is accepted, it becomes a legally binding agreement that governs the employment relationship. Acceptance signifies the employee's willingness to enter into an employment agreement and indicates their agreement to the terms and conditions outlined in the offer. Acceptance can be either explicit or implicit, explicit being the overt yes, and implicit being an acceptance by conduct. 3. Consideration. Consideration refers to something of value exchanged between the parties involved in the employment contract. In the context of employment, consideration is usually the employee's promise to provide the work and the employer's promise to provide compensation. For intention to create legal relations for a contract to be enforceable, there must be an intention on both parties to create a legal relationship. For employment, it is presumed that both the employer and the employee intend to create a legally binding relationship unless evidence suggests otherwise. Capacity. Capacity may be an issue for employment contracts, though the situations are limited. A contract with a minor cannot be enforced against the minor, though it can be enforced against the adult party. For example, imagine a 16-year-old high school student signs a written contract of employment to work as a server in a local restaurant. Because the student is a minor, the restaurant cannot enforce the contract against the student, but the student could choose to enforce the terms against the restaurant. Additionally, individuals with mental incapacity may have limited capacity to enter into contracts, depending on the circumstances. 6. Legality. The purpose of the employment contract must be a legal one. A contract that involves illegal activities or violates public policy will not be enforceable. For example, imagine a corporation hires an individual specifically to forge documents for clients. Since the terms of the employment contract involve illegal activities, the contract is void and unenforceable. Sources of contractual terms. The terms of an employment contract can come from various sources, including statutory laws, common law principles, collective agreements, and the contract itself. The full spread of the employment terms, in many cases, contains a mix of each. Statutory law employment relationships in Canada are governed by a variety of federal and provincial territorial laws. These laws set out minimum standards for the employment. For example, the Employment Standards Act establishes rules regarding minimum wage, hours of work, overtime pay, vacation entitlements, and termination notice or pay. These laws imply these protections into the employment relationship and typically cannot be waived. Common law principles also play a significant role in shaping the terms of an employment contract. Courts have recognized certain implied terms that are considered to be part of every employment contract, even if they are not explicitly stated in a written contract. These implied terms will be discussed more at length in the following section. Collective agreements in unionized workplaces. The terms of employment are determined through collective bargaining between the employer and the union representing the employees. The resulting collective agreement outlines the rights, responsibilities, and conditions of employment for the unionized employees. Collective agreements have the force of law and supersede individual employment contracts for employees within the bargaining unit. As noted at the start of the chapter, the law relating to unionized workplaces will not be canvassed. However, it is worth noting how the collective agreement is the source of employment terms for unionized workers. Individual contracts, the negotiated terms of the employment contract, form the essence of the relationship between the employer and the employee. It makes sense that the written or verbal contract can expand on the terms of that relationship. Express, ancillary, and implied contract terms as noted above. The terms of employment can come from a cross-section of different sources. This mix can result in some terms being expressly defined in the agreements versus other terms which are implied. Express terms are explicitly agreed upon by the employer and employee and are typically set out in writing. Express terms can cover a wide range of issues, such as compensation, working hours, job duties, benefits, termination procedures, and any other specific terms agreed upon by the parties. What is clear about express terms, regardless of scope, is that they are clearly expressed and agreed to by the parties. In addition to express terms, company policies, or handbooks can also play a significant role in determining the terms and conditions of employment. These ancillary policies may cover areas such as a code of conduct, disciplinary procedures, leave policies, confidentiality agreements, social media use, and other rules and regulations that employees are expected to follow. While these policies may not be individually negotiated with each employee, they can have legal enforceability if they are communicated to the employee and included in the contract. For example, if an employment policy prohibits discrimination or harassment, this policy would be enforceable if FOUNDATIONSOFCANADIANBUSINESSL a W-199 the employee is aware of the policy and the policy is properly incorporated or referenced in the employment contract. Implied terms, on the other hand, are not explicitly stated but are assumed to be part of the employment relationship. These terms are typically required because statutes passed by the various levels of government demand them into the employment contract, or they are implied because of common law. Examples of implied terms may include the duty of an employer to provide a safe working environment, the duty of an employee to perform their job competently, and the duty of both parties to act in good faith during the employment relationship. Implied terms are not specifically negotiated but do legally exist in the employment contract. Taking all this together, the employment terms are often more than just the written contract. It is all the myriads of other employer policies which are properly incorporated in the employee's agreement, and also those implied by law. Common contract terms. The following discussion highlights some of the major or most common expressed terms in an employment contract, including probationary clauses, ownership of intellectual property clauses, restrictive covenants, and termination clauses. Myth-busting myth. All I need to read in the employment contract is the salary and job duties. The myth that the only important terms in an employment contract are the salary and job duties overlook the critical aspects that come after. Terms such as probation, ownership of intellectual property clauses, restrictive covenants, and termination clauses play a significant role in defining the employment relationship. Therefore, it is crucial to thoroughly review and understand the entirety of the employment contract to properly understand and protect your rights. Probationary clauses refer to a period of time during which an employee's job performance is evaluated to determine if they are suitable for long-term employment with the company. Probation provides employers with a degree of flexibility in managing their workforce, as they can terminate an employee if they are not meeting the employer's expectations during the probationary period. In order for an employee to be placed under a probationary period, there must be a probation clause in the contract. While the probationary period is typically understood as 3 months, there is actually no standard length of time for probation. Employers can use a time period which they feel is required to suitably assess the employee. Perhaps that is a few weeks or several months. During the probationary period, an employer can monitor the employee's performance. If the employee meets the company's expectations, they will be confirmed as a permanent employee. If not, the company may choose to terminate the employee's employment. Example: probationary clause. The following is a standard example of a probationary clause in an employment contract. Upon commencement of employment, the employee will be subject to a probationary period of 4 months. During this period, the employee's performance, conduct, and suitability for the position will be evaluated. This probationary period is intended to provide both the employee and the employer an opportunity to assess the working relationship and determine if it meets their respective expectations. Even if a probationary period is set in the contract, a probationary clause may not be enforceable unless it meets a specific legal test. Legal tests to enforce a probationary clause. In determining enforceability of a probationary clause, a court will consider: 1. Whether the employee was made aware of the basis for the employer's assessment of suitability before or at the commencement of employment. 2. Whether the employer acted fairly and with reasonable diligence in assessing suitability. 3. Whether the employee was given a reasonable opportunity to demonstrate his or her suitability for the position. And 4. Whether the employer's decision was based on an honest, fair, and reasonable assessment of the suitability of an employee, including not only job skills and performance, but also character, judgment, compatibility, and reliability. Live v. British Columbia, 2017, BCSC 42 at para. 58. While probation may be used to dismiss an employee, the employer still has to follow the requirements set out in the Employment Standards Act and the common law, such as providing notice or pay in lieu of notice. Foundational law, Lai v. British Columbia, 2017 BCSC 42. Phuc Lai was hired as a manager by the Interior Health Authority. However, his employment was terminated after about 2.5 months without any notice or pay in lieu of notice. The employer relied on a probationary clause in Lee's employment offer which stated that employees are required to serve an initial probationary period of 6 months for new positions. In his lawsuit, Lai argued, among other things, the Interior Health Authority had failed to conduct a fair assessment of his suitability for the job, which meant they could not rely on the probationary clause as the basis for avoiding reasonable notice of termination. The court concluded that Lai had genuinely made efforts to understand the employer's expectations and the criteria by which he would be evaluated. However, the employer failed to adequately address his inquiries or provide him with a fair opportunity to demonstrate his suitability for the position. Ultimately, the employer did not meet the required standard of good faith, and therefore, the probation clause was not effective to avoid the notice obligations. As a result, Lai was entitled to damages equivalent to a reasonable notice period of 3 months. Ownership of intellectual property clauses in many employment settings. The employee is not only a service provider or a technician, but can also be a creator, who then owns the intellectual property rights in employee creations. Generally, the law of intellectual property states that the owner of intellectual property is the creator. As a starting point, then, any works created by an employee should be the sole right of that employee. However, it is often the case that employers want to override that presumption through the written employment contract. Employers can include intellectual property clauses or IP clauses in the contract to alter the presumption of ownership over the works created by the employee. In almost all cases, an employer-required intellectual property clause will seek to establish that the employer is the ultimate owner of the intellectual property rights, even if the creation was done by the employee. Example: ownership of intellectual property clause. The following is a standard example of an ownership of intellectual property clause in an employment contract. The employee acknowledges and agrees that all intellectual property created, conceived, or developed by the employee, whether during working hours or outside of working hours, and whether or not utilizing company resources, shall be the sole and exclusive property of the employer. Examining the language, it is clear that there are broad rights granted to the employer for any creation done by the employee during working hours, but also potentially done outside of the workplace. Importantly, courts will not enforce intellectual property clauses which are vague or overly broad. A good reflection of this limit is the Alberta case of Quester Technology, Inc. v. Stagg, 2020 ABQB 3 highlighted below. Foundational law, Lai versus Quester Technology, Inc. v. Stagg, 2020 ABQB 3 Quester, an environmental technology company specialized in selling custom incinerators designed for the oil and gas industry. Stagg were previously employed by Quester, and during their time as employees, they developed a waste gas combustion solution at low pressure. Upon leaving Quester, Stagg and the others established their own company and introduced a competing low-pressure waste gas incinerator that was similar to the emission LP burner technology. Quester asserted that they owned the rights to the emission LP burner technology because the contracts of employment with Stagg and the others contain an ownership of intellectual property clause. The specific clause at issue stated the following: Quester shall have all proprietary rights and exclusive ownership, including, but not limited to, exclusive copyright, in and to all written, recorded, or visual materials, compilations of information or data, and other works of authorship, furnished to Quester and developed by me in connection with my employment with Quester. I agree to fully cooperate and to do all things reasonably necessary to allow Quester to claim sole copyright ownership, including the execution of documents for that purpose. I agree to keep such employment work products in confidence and to use them solely in the performance of my employment with Quester, unless expressly authorized in writing to do otherwise. The language of the IP clause indicated that it covered the ownership of various forms of creative works, including written, recorded, or visual materials, compilations of information or data, and other works of authorship. While copyright was clearly emphasized, there was no explicit mention of ideas or inventions which are typically protected as intellectual property under patents. According to the court, in the absence of clear language stating that Stagg or the others granted ownership of any inventions to Questa, the court was unwilling to enforce the clause. Therefore, Stagg and the others, as the inventors, retained ownership of the emission LP burner technology. Restrictive covenants are legal clauses in an employment contract which impose certain limitations or restrictions on the employee's activities even after leaving the organization. The use of restrictive covenants can sometimes be controversial as it limits the employee's liberty and employment options after their current employment has ended. At their core, restrictive covenants are intended to protect the employer's legitimate business interests, such as confidential information, trade secrets, customer relationships, or proprietary knowledge. While Canadian courts generally scrutinize restrictive covenants to ensure they are reasonable and necessary, certain types of restrictive covenants can, in many cases, be legally enforceable. Non-disclosure agreements and confidentiality clauses. Non-disclosure clauses or confidentiality clauses are the least controversial of all the restrictive covenants. Such clauses prohibit employees from later disclosing or using confidential or proprietary information they obtained during their employment. Accordingly, under a non-disclosure clause, employees cannot disclose information like trade secrets, client lists, marketing strategies, or manufacturing processes, etc. Courts have long found that requiring an employee to maintain confidentiality even after the employment has ended is a fair concession in employment. Given that an employee is privy to confidential and sensitive information as an employee, it is only fair that they maintain that confidentiality even after leaving the workplace. For example, it is reasonable to require a software developer to sign a confidentiality clause under their employment promising not to share the company's source code or any other confidential information with any person not authorized by the employer. Example: non-disclosure clause. The following is a standard example of a non-disclosure clause in an employment contract. The employee acknowledges and agrees that during the course of their employment with the company, they may have access to and become familiar with certain confidential and proprietary information of the company, its clients, suppliers, and other third parties. Confidential information includes, but is not limited to, trade secrets, customer lists, financial information, business plans, marketing strategies, software, technical data, inventions, and any other information that is not publicly available. Non-solicitation clause. The middle ground for restrictive covenants, likely to be enforceable in most cases, are non-solicitation clauses. Non-solicitation clauses prohibit employees from soliciting or poaching clients, customers, or other employees of their former employer for a certain period after termination. The non-solicitation obligations are subject to a time frame established in the clause itself and can range from a few weeks to potentially 2 years. Non-solicitation clauses aim to safeguard a company's relationships and prevent unfair competition. For example, it is reasonable for a sales representative to agree that they will be restricted from contacting their former clients or attempting to recruit colleagues from their previous organization for a period of 6 months after leaving the company. Example: non-solicitation clause. The following is a standard example of a non-solicitation clause in an employment contract. During the term of employment and for a period of 1 year following the termination of employment, the employee agrees not to directly or indirectly 1.1 solicit customers, engage in any activity or conduct that may directly or indirectly solicit or attempt to solicit any client, customer, or account of the company with whom the employee had material contact, connection, or relationship during the course of employment, for the purpose of providing products or services similar to those offered by the company. 1.2 Solicit employees. Recruit, hire, employ, or solicit the services of any current employee, contractor, or consultant of the company, or induce any such person to terminate or diminish their relationship with the company. Non-competition clause. The most controversial clauses are non-competition clauses, otherwise known as non-competes. Non-competition clauses prevent employees from working for or starting a competing business within a specified geographic area and time frame after leaving their current employer. Example: non-competition clause. The following is a standard example of a non-competition clause in an employment contract. The employee acknowledges and agrees that during the course of their employment with the company, they may have access to and become familiar with certain confidential and proprietary information of the company, its clients, suppliers, and other third parties. Confidential information includes, but is not limited to, trade secrets, customer lists, financial information, business plans, marketing strategies, software, technical data, inventions, and any other information not publicly available. The sample clause in the example demonstrates the precise concern with non-competition clauses. They bind the employee after the employment has ended and limit the employee's ability to practice their chosen vocation for a defined period of time. Is it truly a fair compromise that the employee agrees to limit their chosen work opportunities even after they have left their current employer? Myth-busting myth. I'm under a non-compete, so I cannot work for a competitor if I quit or am fired. Incorrect. It's a common misconception that all non-competes are binding. While such clauses do exist and are used by employers to protect their business interests, courts often scrutinize them closely and may find them unenforceable if they are deemed too restrictive, unreasonable, or unclear. Courts recognize that non-competes can have a significant impact on an individual's ability to find employment and make a living. As a result, they are very critical of such clauses to ensure they are fair and reasonable. If a non-compete is found to be overly broad or unreasonable, courts have the authority to declare it unenforceable. Enforceability of restrictive covenants. All of the three types of restrictive covenant are subject to the same general legal test for enforceability. Legal test for enforcing a restrictive covenant. The court will examine the following factors to determine enforceability of a restrictive covenant. 1. Does the covenant protect a legitimate proprietary interest of the employer? 2. Is the covenant reasonable between the parties in terms of temporal length, spatial area covered, nature of activities prohibited, and overall fairness? 3. Are the terms of the covenant clear, certain, and not vague? And 4. Is the covenant reasonable in terms of the public interest? Orem Ceramic Dental Laboratories Ltd. versus Huang, 1998, Kenai, 5759 at Para. 11. All an employee needs to do to avoid the application of the restrictive covenant is to demonstrate that the legal test is not completely met. One deficiency in the test will render the entire clause unenforceable. For an example of this process, see the example below. Example: reasonableness analysis of restrictive covenant. Lok Feng, a human resources associate, signed a non-compete agreement with XYZ Corporation upon joining the company. The non-compete agreement included the following provisions. The agreement prohibited Lok Feng from working for any competitor of XYZ Corporation for 10 years after the termination of their employment. The non-compete agreement restricted Lok Feng from working for any competitor within a 200-kilometer radius of XYZ Corporation's locations, including its headquarters. Lok Feng was barred from engaging in any work or activities that directly or indirectly competed with XYZ Corporation's human resources services. Reasonableness analysis. Temporal length. A 10-year restriction is excessively long and would be considered unreasonable. Spatial area covered. The 200-kilometer radius restriction is overly broad and unnecessarily limits Lok Feng's job prospects in the HR field. Nature of activities prohibited. The broad prohibition on all indirect HR or related activities restricts Lok Feng's career options in an unreasonable. The clause should be clearer on what it is restricting. Termination clauses. One of the interesting facets of Canadian employment law is that all employers are under an implied obligation to provide the employee with reasonable notice or payment in lieu of that notice if the employee is be terminated. What this means is that employees must be given notice of their termination, which, as will be discussed later, can be quite extensive. Employers who wish to modify or lessen this notice period can include termination clauses in their employment contracts. Termination clauses are written contractual clauses that define the amount of notice or pay in lieu of notice that an employer must provide to an employee upon termination. Termination clauses are often used to limit severance obligations and provide certainty to both the employer and the employee about what is owed on termination. Termination clauses are extremely enticing for employers because, by limiting severance obligations, it can help employers manage their financial liabilities when terminating employees. Not all termination clauses will be enforceable. To be legally enforceable, termination clauses must meet certain requirements. Legal test for enforcing a termination clause. The court will examine the following factors to determine the enforceability of a termination clause. 1. Is the termination clause expressed in the contract? 2. Is the termination clause clear and unambiguous? And 3. Does the termination clause offend the relevant employment standard legislation? McMahon v. Maximizer Services, Inc., 2023 BCSC 4 at Paris. 18 to 25 on the third criteria of the test. The termination clause must not provide less than the minimum required by the provincial territorial employment standards legislation. If a termination clause provides less notice or pay than the minimum required by that legislation, the clause will be unenforceable. For example, what about the following clause? Upon termination, the employer will not provide the employee with notice or pay in lieu of notice. This clause clearly falls short of the minimum standards set by the legislation because there is no notice given by the employer at all. Every employment standards legislation requires some notice to be given to the employee based on the employee's length of service. Employment standards legislation across Canada. The provinces and territories have passed specific employment standards legislation to govern various aspects of the employment relationship. These laws establish minimum standards and protections for workers in areas such as wages, hours of work, overtime pay, vacation and holiday entitlements, leaves of absence, termination and severance pay, and other employment-related matters. The purpose of employment standards legislation is to ensure fair and equitable treatment of employees, protect their rights, and promote decent working conditions. The legislation sets out a series of baselines that employers must comply with. Generally, the employment standards legislation applies to most workers. However, there are certain exclusions for groups such as independent contractors, agricultural workers, and professionals who are regulated by their respective governing bodies. The specific details and coverage of employment standards legislation can vary significantly between different provinces and territories. However, they also share some similarities. Readers are encouraged to review their own provincial statute to determine their precise legal protections. The British Columbia Employment Standards Act. The following will describe some of the major protections under the British Columbia Employment Standards Act, 1996 RSBC, C. 113. Minimum wage. The ESA mandates that all employees are entitled to be paid a minimum wage for their work. The actual amount of the minimum wage is set by the Employment Standards Regulation and is periodically reviewed to reflect changes in the cost of living. Hours of work and overtime. The ESA regulates the maximum number of hours an employee can be required to work in a day or a week. British Columbia, unlike some other provinces, has a daily overtime entitlement and a weekly overtime entitlement. Daily overtime. If an employee works more than 8 hours in a single workday, they are entitled to overtime pay. The daily overtime rate is 1.5 times the employee's regular wage for each hour worked beyond 8 hours in a day up to 12 hours in a day. Following 12 hours of work, the employee is then entitled to 2.0 times the regular wage on subsequent overtime. Weekly overtime. In addition to daily overtime, the ESA also mandates weekly overtime. If an employee works more than 40 hours in a workweek, they are eligible for overtime pay. The weekly overtime rate is 1.5 times the regular wage for each hour worked beyond 40 hours in a week. Statutory holidays. The ESA outlines the public holidays recognized in British Columbia and the entitlements of employees who work on those days, including paid time off or premium pay. The following are the current British Columbia statutory holidays: New Year's Day, BC Day, BC Family Day, Labor Day, Good Friday, National Day for Truth and Reconciliation, Victoria Day, Thanksgiving Day, Canada Day, Remembrance Day, Christmas Day. Vacation time. After 12 months of employment, employees are entitled to 2 weeks of vacation time per year. After 5 years of employment, employees are entitled to 3 weeks of vacation time per year. Vacation pay. Vacation pay ensures that employees receive compensation for time off during their annual vacation. Employees are entitled to receive 4% of their total employees' wages as vacation pay following 5 days of work. Following 5 years of employment, the vacation pay percentage increases to 6%. When an employee takes their vacation, the employee will use the banked vacation pay to compensate the employee. Liability for length of service. After completing 3 consecutive months of employment, an employee becomes eligible for compensation based on their length of service if their employment is terminated by the employer. The compensation or written notice required by the employer increases as the employee's length of service progresses. The employer must adhere to the following payment or notice requirements. After 3 consecutive months of employment, 1 week's pay or 1 week's written notice. After 12 consecutive months of employment, 2 weeks' pay or 2 weeks' written notice. After 3 consecutive years of employment, 3 weeks' pay or 3 weeks' written notice, along with an additional week's pay or notice for each subsequent year of employment, up to a maximum of 8 weeks. Leaves of absence. The ESA includes provisions for various types of leaves, such as maternity leave, parental leave, compassionate care leave, and family responsibility leave. These leaves provide job protection and, in some cases, wage replacement for eligible employees. Enforcing the ESA, the Employment Standards Branch, is the government agency responsible for administering and enforcing the ESA. Its role includes educating employers and employees about their rights and obligations under the legislation, conducting investigations, and resolving complaints related to employment standards. If an employee is having a workplace right violated, they can file a formal complaint to the ESB by completing an online complaint form. Once the complaint is submitted, the ESB will review it and open an investigation. The ESB will likely contact the employer for a response and gather additional information. If a resolution cannot be reached through mediation or negotiation, the complaint will be determined by an ESB adjudicator. 210F OUN DATION SOFCA NAD IANBUS INESSLAW. When a party disagrees with a decision made by the ESB, they can file an appeal with the Employment Standards Tribunal. The EST reviews the underlying case, considers the evidence presented by both parties, and makes a decision based on the merits of the appeal. The EST issues a written decision which may confirm, vary, or overturn the original decision made by the ESB. The decision of the EST is final and binding unless it is appealed to the British Columbia Supreme Court on a question of law. Employment terminations in Canada. In Canada, the termination of employees can occur on 2 large legal bases, either with cause or without cause. Both forms are seismically different in the financial obligations on employers and the potential impacts on employees. Terminations for just cause. Just cause is the capital punishment crime of employment law. Tong v. Home Depot of Canada, Inc., 2004, KNII 18228 at para. 1. Termination with cause refers to situations where an employer terminates an employee's employment due to serious misconduct or a fundamental breach of the employment agreement. Just cause dismissals are generally considered to be the most serious form of disciplinary action an employer can take, as it severs the employment without any reasonable notice or pay in lieu. When terminating an employee with cause, the employer is not required to provide notice or severance pay. This can be extremely beneficial as it allows the employer to immediately dismiss the employee and avoid any continuing financial or notice obligations. While the employee would still be entitled to any wages or benefits earned up to the date of termination, they would not be entitled to any further severance. Myth-busting myth. My employer told I was dismissed for misconduct. They said I'm not entitled to any compensation or severance. Incorrect. In reality, just cause for termination is a very high standard that requires employers to prove both that the misconduct occurred and that its severity warranted summary dismissal. Some employers may rely on just cause as a justification for termination, but they would fail to meet this high threshold of proof. As a result, many terminations claiming to be for just cause might be challenged by employees as wrongful dismissals, and the employee may be entitled to legal damages. In order for an employer to justify a just cause dismissal, they must be able to demonstrate that the employee's actions or behavior were so serious that the employment relationship has been irreparably damaged. The burden of proof lies on the employer, and if the employer cannot prove the misconduct, then the employee could bring a wrongful dismissal action. Legal test for just cause. The case of McKinley v. B.C. Tell, 2001 SEC 38, establishes a two-part test for determining whether just cause is proven. That the evidence establishes the misconduct. The employer must have evidence that the employee engaged in the alleged form of misconduct. It is not sufficient to use cause for the suspicion of wrongdoing. Rather, the employer must have evidence that proves, on balance, the employee committed the misconduct. To satisfy this burden, employers should launch a good faith investigation of the misconduct allegations. The misconduct warranted summary dismissal. The employer must demonstrate that the employee's misconduct was of such a serious nature that it warranted immediate termination without any notice or severance pay. This requirement is often referred to as summary dismissal or summary termination. It means that the misconduct was severe enough to fundamentally breach the employment contract or to undermine the employment relationship to the point where continued employment is no longer feasible. Based on the McKinley test, not every misconduct will rise to the threshold of just cause. Instead, the employer needs to prove that misconduct actually occurred and warranted the summary dismissal of the employee. Foundational law. McKinley v. B.C. Tell, 2001 SEC 38. McKinley was a chartered accountant who was employed by B.C. Tell starting in 1993. McKinley began experiencing hypertension, which led to high blood pressure. By June 1994, his blood pressure was consistently rising, prompting him to follow his physician's advice and take a leave of absence from work. McKinley expressed his desire to return to work, but requested a position with less responsibility. B.C. Tell assured him that they would make efforts to find a suitable role for him within the company. However, on August 31, 1994, B.C. Tell decided to terminate McKinley's employment. At the time of termination, McKinley had been working for B.C. Tell for nearly 17 years and was 48 years old. Rather than accepting B.C. Tell's severance offer, McKinley asserted that his employment had been unjustly terminated without reasonable notice or pay in lieu of notice. As a result, he initiated a wrongful dismissal lawsuit in the B.C. Supreme Court. B.C. Tell partly defended their decision by claiming just cause for McKinley's summary dismissal. They alleged that he had been dishonest about his medical condition and the available treatments for it. In the case, the SEC established the two main principles for relying on just cause: whether the evidence established the employee's deceitful conduct on a balance of probabilities, and if so, whether the nature and degree of the dishonesty warranted dismissal. Applying the law to the facts, the SEC held that although McKinley may not have fully disclosed all relevant information regarding his treatment and medication options, the jury at trial could have reasonably determined that he did not act in such a dishonest way as to be incompatible with his employment. Therefore, just cause was not supported, and McKinley's victory trial was upheld. Just cause disputes occur in a variety of factual scenarios. Among others, employees may be dishonest, insubordinate, incompetent, breach a company policy, or commit some form of off-duty misconduct. Given that each of these are different forms of misconduct, various factors have been established to determine if just cause is met. Dishonesty. Imagine an employee is caught stealing from their employer or falsifying their timesheets. This dishonesty may allow the employer to dismiss without providing notice or severance. The employee's dishonesty must be of such a nature that it fundamentally undermines the employment relationship, breaches the trust between the employer and employee, or impacts the employee's ability to fulfill their duties effectively. The seriousness of the offense is assessed based on the context, nature of the job, and the impact of the dishonesty on the employer's legitimate interests. Ultimately, then, the employer must establish that the dishonesty was of sufficient gravity to undermine the employment relationship. This objective assessment considers whether a reasonable person, with full knowledge of the circumstances, would conclude that the dishonesty undermines the essential trust required for the employment relationship to continue. 2. Insubordination. Insubordination refers to an employee's willful refusal to comply with a reasonable and lawful instruction given by their employer. If an employer has failed with an employee who simply will not comply with its instructions, this could permit the employer to rely on cause as the basis for the dismissal. Legal test for insubordination. When determining just cause based on insubordination, The court considers the following elements. 1. The order must be either clear and specific or must be a breach of policies and procedures well known by the employee. 2. The order must be within the scope of the employee's job duties. 3. The order must be reasonable and lawful. 4. The disobedience must be both deliberate and intentional rather than resulting from an honest mistake as to whether the order was still in effect or under the reasonable belief that he was not contravening orders. 5. The order must involve some matter of importance. Unless the act of disobedience is particularly serious, it has to be repeated, rather than be an isolated act of disobedience, in order to constitute cause. 6. It must be shown that as a result of the disobedience, the relationship was so damaged that it could not be carried on. 7. It must be shown that the employee understood or should have understood that he ran the risk of being terminated for disregarding the order. 8. If there is a reasonable explanation for the disobedience, it will not be cause for discharge. And 9. There will be more latitude shown to long-service employees. Bedoin v. Agriculture Financial Services Corporation, 2018 ABQB 627 at para. 46.3. Incompetence. When can an employee's incompetence rise to just cause? For example, what if an office worker is consistently unable to complete assignments accurately or on time, despite being provided with clear instructions? At what point can the employer simply say that the employment is no longer possible? Establishing just cause for incompetence requires an employer must be able to demonstrate that the employee is unable to perform the essential duties of their job to an acceptable standard, despite being provided with adequate training, supervision, and support. An employee may assert that they have been wrongfully dismissed if the employer contributed to the inability of the employee to meet the standard because of inadequate training or support. For breach of company policy, employers often have a myriad of company policies which provide clear instructions to employees about company expectations and operations. These policies can include workplace code of conducts, conflict of interest policies, workplace harassment policies, confidentiality policies, or a general employee handbook. A breach of one of these company policies could be considered grounds for a just cause dismissal. A breach of company policy occurs when an employee violates the rules and guidelines established by their employer. Legal tests for breach of company policy as just cause. When determining just cause based on breach of company policy, the court considers the following elements. 1. The rules must be distributed. 2. The rules must be known to the employees. 3. The rules must be consistently enforced by the company. 4. The employees must be warned that they will be terminated if a rule is breached. 5. The rules must be reasonable. 6. The implications of breaking the rules in question are sufficiently serious to justify termination. And 7. Whether a reasonable excuse exists. Balzer v. Federated Cooperatives Limited, 2014 SKQB 32 at para. 61. In summary, to establish just cause, the breach of company policy must be sufficiently serious and demonstrate a significant impact on the employment relationship. Off-duty misconduct. Off-duty misconduct refers to situations where an employee engages in conduct during their personal time that affects their employer's interests, reputation, or the employment relationship itself. FOUNDATIONSOFCANADIANBUSINESSL a W215 myth-busting myth. What happens in my personal time cannot affect my employment. Incorrect. Employees should absolutely be aware that what happens off-duty can have job consequences. If an employee engages in misconduct during their personal time that harms or undermines the employer's interests or is incompatible with their job duties, it can provide legitimate grounds for a just cause dismissal. While employees have a right to a personal life outside of work, employers have a legitimate interest in protecting their reputation, ensuring a safe and productive work environment, and maintaining employee conduct consistent with the company's values. Therefore, off-duty misconduct can, in fact, support a just cause termination in specific circumstances. Off-duty misconduct can potentially be grounds for dismissal, with just cause allowing the employer to terminate the employee without providing notice or severance pay. Legal test for breach of company policy as just cause. Interestingly, the clearest articulation of principles relating to a legal test for off-duty misconduct comes from labor arbitration decisions. While such decisions engage different areas of law from employment, the factors used do reflect considerations for a court hearing a wrongful dismissal case. That said, the following factors are relevant to determining if off-duty conduct is sufficient for cause. 1. The conduct of the griever harms the company's reputation or product. 2. That the griever's behavior renders the employee unable to perform his duties satisfactorily. 3. The employee's behavior is to refusal, reluctance, or inability of the other employees to work with him. 4. The griever has been guilty of a serious breach of the criminal code, and thus rendering his conduct injurious to the general reputation of the company and its employees. 5. Places difficulty in the way of the company properly carrying out its function. Edmonton v. Edmonton Firefighters Union, 2015, KII 103790 as examples. Some of the following forms of off-duty misconduct may be sufficient to warrant just cause. Criminal convictions. If an employee is convicted of a serious crime that is incompatible with their employment or has a direct impact on the employer's reputation, such as fraud, theft, or assault, it may be grounds for dismissal. Significant social media misconduct. Inappropriate or offensive behavior on social media platforms, such as posting discriminatory or defamatory comments about the employer, coworkers, or clients, may constitute just cause if it damages the employer's reputation or causes a hostile work environment. Conflict of interest. Engaging in activities or business ventures outside of work that create a conflict of interest with the employer's interests or competing with the employer without proper disclosure and consent can be grounds for dismissal. These categories are not exclusive, and other forms of off-duty misconduct may support just cause. 6. Condonation. We have already seen a variety of arguments that employers can raise to assert a just cause dismissal. However, the use of just cause may not be available if an employer has condoned the misconduct that they are now using to assert cause. Condonation is the act of forgiving or overlooking an employee's wrongdoing. This can occur if an employer chooses not to take disciplinary action against an employee for a particular offense or misconduct. For example, imagine if an employee is habitually late for work but is never disciplined by the employer. Now, the employer decides to terminate the employee and uses the lateness as the basis for cause. The employee may argue that the termination is wrongful because the employer condoned the employee's habitual late arrival. To avoid condonation problems, employers are advised to always take steps to discipline an employee for misconduct to limit an employee's argument of condonation. Terminations without cause. Termination without cause occurs when an employer decides to end the employment relationship without any specific fault or misconduct on the part of the employee. This could be due to various reasons, such as restructuring, downsizing, economic factors, or poor performance that falls short of justifying termination with cause. There are a variety of ways in which employees can be terminated without cause. These include layoffs, notice of the dismissal, and constructive dismissal. While each of the dismissal forms result in the termination of the employment, they implement that termination in different ways and may lead to potential liabilities for the employer. Layoffs. Layoffs occur when an employer needs to reduce its workforce due to reasons such as financial difficulties, restructuring, or technological advancements. Layoffs are usually considered involuntary terminations, and they typically affect multiple employees rather than targeting specific individuals. While layoff is a common term in the business world, layoffs are restricted in Canadian law. The use of layoffs may only be permitted when the right to lay off is written in the employment contract, the right to lay off is implied by the industry of the employer, or the employee otherwise consents to the temporary layoff. Dismissals. Dismissal refers to the termination of an employee's contract by the employer. As mentioned above, the dismissal could be on a for-cause basis or may be on a without-cause basis. In a without-cause dismissal, the employer will be required to provide reasonable notice or pay in lieu of notice. Constructive dismissal. Constructive dismissal occurs when an employee resigns from their position due to the employer's behavior or actions that fundamentally breach the terms of the employment contract. Although the employee initiates the termination by resigning, it is legally treated as a termination by the employer's conduct. Examples of actions that may lead to constructive dismissal include significant changes in job responsibilities, demotion without valid reason, or creating a hostile work environment. Employees facing constructive dismissal may be entitled to wrongful dismissal damages. Implied term of reasonable notice for without cause dismissals. The employer is generally required to provide notice or pay in lieu of notice, or a combination of both. This is because all Canadian employment agreements have an implied term that states employers are required to provide the employee with reasonable notice or pay in lieu of that notice period. The purpose of reasonable notice is to give the employee a reasonable amount of time to find another job and to allow them to make necessary arrangements for the loss of their income. The purpose of the implied term of reasonable notice in an employment contract is to permit the employee to order his affairs and to seek alternate employment. Dunlop v. BC Hydro and Power Authority, 1987, Ken II, 2734 at para. 9. Determining the notice period. When it comes to determining the notice period for a without cause dismissal, there are two primary approaches: following the provincial employment standards legislation or following the common law. These approaches provide rough guidelines for determining how much notice must be provided to an employee dismissed without cause. Provincial employment standards as noted earlier in this chapter. Each province has its own core employment standards legislation. One of the provisions in such statutes are obligations dealing with how much compensation is owed to an employee on a without cause dismissal. In most provinces, such as British Columbia and Ontario, the employment standards legislation specifies a minimum notice period based on the employee's length of service. This approach can require a notice period in the range of 1 week of notice for every year of service, up to a certain maximum. Section 63 of British Columbia's ESA establishes clear benchmarks based on an employee's length of service to their employer. 0. 3 months, none. After 3 months, up to 12 months, 1 week. After 12 months, up to 3 years, 2 weeks. After 3 years, up to 4 years, 3 weeks. After 4 years, up to 5 years, 4 weeks. After 5 years, up to 6 years, 5 weeks. After 6 years, up to 7 years, 6 weeks. After 7 years, up to 8 years, 7 weeks. After 8 years, 8 weeks, no notice or pay is required for employees with less than 3 months of employment. There is also a hard cap of 8 weeks for any single employee dismissed without cause. The amounts listed above are only for individual terminations. The British Columbia ESA prescribes more compensation to be given in scenarios where there are mass or group terminations by the employer. Section 64 of the ESA codifies the following notice periods for group terminations. At least 8 weeks if 50 to 100 employees will be affected. At least 12 weeks if 101 to 300 employees will be affected. Or at least 16 weeks if 301 or more employees will be affected. The employer can meet their statutory obligations by providing the employee advance notice of the termination or by paying the employee in lieu of that notice. 2. Common law. The reasonable notice period may also be determined by reference to the common law. The common law approach to determining the notice period is often more flexible and takes into account various factors beyond just the employee's length of service. The FOUNDATIONSOFCANADIANBUSINESSL, a W-219 essence of the common law approach, is to establish an amount of time that would be required for the employee to secure alternate employment. Unlike the 1 week per year of service codified by some provincial employment standards legislation, the common law establishes a rough starting point of 1 month of notice for every year of service. However, this is not an absolute rule and can be subject to adjustment based on certain factors that emerge from one of the most important cases in Canadian employment law. Bardal v. Globe and Mail, 1960 Kenai 294 Bardal, involved an employee named Edwin Bardal who sued his former employer, the Globe and Mail newspaper, for wrongful dismissal. In the case, the court reaffirmed the well-established law that when an employer terminates an employee without just cause, the employee is entitled to reasonable notice or payment in lieu of notice. Justice Hall, who presided over the Bardal case, identified several factors that are to be considered in determining the employee's reasonable notice period. These factors have become known as the Bardal factors and are widely accepted as the basis for calculating reasonable notice in Canadian employment law. There can be no catalog laid down as to what is reasonable notice in particular classes of cases. The reasonableness of the notice must be decided with reference to each particular case, having regard to the character of the employment, the length of service of the servant, the age of the servant, and the availability of similar employment, having regard to the experience, training, and qualifications of the servant. Bardal v. Globe and Mail Ltd., 1960 Canai 294. The following are the core Bardal factors. Length of employment. The court takes into account the length of time the employee has been with the company. Generally, the longer the employee's service, the longer the reasonable notice period should be. Age of the employee. The court considers the employee's age at the time of dismissal. Older employees may require a longer notice period to secure comparable employment due to their potentially reduced employability. Character of the employment. The nature of the employee's position is taken into account. Higher-level positions with specialized skills or responsibilities may require a longer notice period to find comparable employment. Availability of similar employment. The court considers the availability of other job opportunities for the employee in their particular industry or geographic area. If there are limited job prospects, a longer notice period may be warranted. These factors are not exhaustive or rigidly defined, but rather serve as a guide for the courts in determining reasonable notice. Each case is evaluated based on its unique circumstances, and other relevant factors may also be considered. Ultimately, the Bardal factors provide useful framework for courts to assess the length of the reasonable notice period, taking into account factors such as length of service, age, position, and the availability of comparable employment. This case remains seminal law and has since been cited as a precedent in hundreds of subsequent Canadian employment law cases. Failure to provide proper notice under provincial employment standards legislation. What happens if an employer fails to provide the required statutory notice? Should an employee not be provided with their statutory minimum notice as required under their provincial standards legislation, they may pursue a complaint to the appropriate employment standards organization. By way of example, if an employee in British Columbia was dismissed without cause and not provided the required notice under Section 63 of the BC ESA, they could file a complaint with the BC Employment Standards Branch. The ESB would then open an investigation into whether the employer provided sufficient notice or compensation and, if not, require the employer to provide it. Employers should always remember that without cause dismissals come bound by a statutory obligation to provide some compensation. Failure to abide by that obligation can result in a complaint to the employment standards regulator. Failure to provide proper notice under common law. What happens if an employer fails to provide the required common law notice period? The process for enforcing a claim for common law notice is done through a lawsuit and not through a provincial regulator. Accordingly, a wrongfully dismissed employee must anticipate that they will be suing their employer, which could result in the steps of litigation unfolding. Many dismissed employees will consult with an employment lawyer who can assess the merits of the wrongful dismissal claim and advise on the potential costs associated with the litigation. Dismissed employees generally have a 2-year limitation period starting from the date of termination to pursue their action for reasonable notice damages. Employees' duty to mitigate. Even where an employee is dismissed through no fault of their own, they remain bound by certain legal obligations or duties. As we have seen, these ongoing obligations could include the duty to not disclose confidential information or trade secrets of their former employer. This obligation persists even if the employee was wrongfully dismissed. Another duty which persists is the employee's duty to mitigate. Mitigation refers to the steps that an employee must take to minimize the damages that they have suffered as a result of an employer's wrongful dismissal. This could include looking for new employment or taking on temporary work in order to reduce the amount of lost income. Employees must take steps to mitigate their damages because, in many cases, the amount of damages that an employee can recover in their action is limited by the amount of effort they put into mitigating their losses. For example, if an employee is wrongfully dismissed and they do not take any steps to find new employment, they may not be able to recover as much in damages as they would have if they had actively sought out new work. Chapter 10. Review Questions 1. What is the difference between an employee and an independent contractor? 2. Do I have an employment contract even if I haven't signed a physical document? 3. What are restrictive covenants and are they enforceable? 4. What is a probationary period and can I be terminated during this time? 5. What is the difference between termination with cause and without cause? 6. How is reasonable notice determined in a without cause termination? 7. What is my duty to mitigate after being dismissed? Optional resource. Multiple choice quiz looking for 20 multiple quiz questions about Chapter 10? Click here to be taken to be a roster of chapter quizzes. Optional resource. Chapter 10 podcast looking for a podcast-style conversation about the content in this chapter? Click the following link to listen to an AI-generated discussion of the major themes in Chapter 10.